Okay, good afternoon, everyone. I have seen some of you all are new face, and some of you might be familiar faces or familiar name because I can recall some of you all have attended last year's session. I wouldn't say nice to see you all again, but so sad to say, but it's true. Welcome back. Okay, so this year, because the constraint of time, I will start with the past year question, but it is the supplement paper for last year. So as everyone can see my screen? All right, so let's start with the compulsory question. So no matter how, when you see this every single paper, right, just get yourself ready for a few colors of the highlight pen because later on you will see how important it is. So let's move to the first one, which is the compulsory question. Okay, so the compulsory question, as everyone know, no one can escape. So you see the reason why I prepare different colors of highlight is because later on, you will have to know are the what are the type of the parties. You see, Densa, this is the first party. So I have prepared and highlighted in first color. You see the first paragraph, Densa has the registered office in Kajang and Selangor. So usually the first and compulsory question, it will start off with, you have to identify the party because later on, you will have to know which is the governing order for this party. Is everyone okay? Okay, so from the second paragraph, Densa enter into a distributorship agreement with Mark Chan and Indran as partners of Ma and Core. You see, this time I've prepared the second color. The reason why? Because Ma and Core is our partners. So can everyone see that? And you see, Ma and Co has a trading address at this particular address, Malacca Raya, Malacca. Okay, this is the address for the firm. Okay, so from these two paragraphs, you will see that the reason why they put their registered office in different address. So anyone have a thought on why they put different address? Correct. Because later on, when they want to file an action, this will determine on which court they have to pursue. So every time when you see the first sentence, first question, this kind of the question will always asking you parties, their jurisdiction, their registered address, because later on you have to file to which particular court and the type of cause of action. Okay. Okay, so now we go on to the third paragraph. The terms, 5 years commencing from this particular date, okay, with an option of renewal. Second thing is to pay Densa, Ma and Chan has to pay Densa a monthly fee of 10,000. And then they have to provide, Densa has to provide and allow the firm to use the building owned by them in Kuala Lumpur. You see, again, it shows an address. So this will determine on the cause of action and then further on which court they have to file. Everyone get it clear? Okay, now you see, for the fourth one, the reason why I didn't highlight it is because I think this is just like a wayang kulit thing lah. But essentially on this part, in the year of January, Chan, the managing partner of the firm, has gave the written notice to iClean Limited on the usage of the machine caused by the malfunction, and then they stopped making the fee since this year. The reason why I highlight it, can everyone tell me the reason of why I highlight the date. Breach is one part. Cause of action is the most important part, because if when we're looking at the first question, right, it generally covers these few fields lah, these few areas. First thing is the party. Second thing is the cause of action. Third thing is the court's jurisdiction, on which particular court you. Sorry, I can hear someone didn't mute their mic. Okay, so you see, just now where were we? Okay, so third thing is which court they can file the action. So from this, I think this is the trend for these few years now. You see, at this particular date, they fail to make the payment. So in the April of 2024, Densa has demanded the payment for the distribution ship. Okay, so Chan disputed on this, okay, blah, 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 until the 6th of August in the year of 2024, they terminated and then gave notice to quit Densa showroom. Now, you see, Chan, although he has replied by a letter claiming that the termination was unlawful, now you have to see the question, who are you advising? Densa. You see, Densa wants to commence a legal action to recover the outstanding distributorship fee and take the possession of the showroom. The first, the Roman one, the first question is that the appropriate party to be named as the party to be sued. Okay, so from the question itself, how many parties we have identified? Anyone? How come it's 3 plus 1? Actually, from the question itself, right, there is only, I would say there's only two, three, sorry, three. Three is correct, because first one is Ma and Call. First one is Densa. Second thing is Ma and Call. Then the third one is iClean Limited, because this one is Densa's largest customer. Okay. Indian. Which one is the Indian? Sorry, Francis. Indran is the partner, so not Indran. Okay, so as you all can see, there are three parties named in this action. So when you are saying that, how do you start off with? First one, use a subheading. Always start off with a subheading. So when you are introducing, you just put a subheading to introduce Densa. Okay, so by saying that Densa is the owner and the manufacturer. Okay, so how would you introduce it? This is Sandrian Bahat. Yeah, densa is the plaintiff, correct. But you also have to introduce it accordingly. Like, how would you all go about? Because you have to use the rules of court to cite, or he is the company, so that how can he be named as the party in the action? How come order 1777 rule 1? He's not a partnership. Now we are talking about densa. So the correct answer is Section 20 Sub 1 Companies Act, because densa is a sendirian berhad. Really, I think you guess something. I think you get something wrong already. She is not the sole proprietor, because in sole proprietor, right, they won't name themselves as Sendirian Berhad, because after the year of 2016, because currently the company is allowed to have one director, unlikely to
Where's my water bottle? Check in the bag. How many water bottle?
previous one, under the old law, a company must have two directors. And now, because they are this one is a Sendirian Berhad, and moving on to the new law, one company can have one director only. And then you can add on, like Ara says that, thank you for the sharing. Order 5, Rule 6, Sub 2, they must be represented by a lawyer. Okay? Now we move to the second party, Ma and Call. What do you all think? He's a partner. They are in a partnership. Correct. This will falls under Order 77, because Mark, Chan, Indran, they are the partner. So in the type of Ma and Call, they can be sued under Order 77, Rule 1. So you can illustrate a bit lah, like they can be sued in under individual partner or in the name of partnership. Okay? So now, yes, thanks for the answer input in the chat group. Okay, now we're talking about iClean Limited. iClean Limited, from the fact itself, okay, this is a company. Company will fall under the same Section 20 Sub 1 of the Companies Act. Is everyone okay on this? Okay, now we come to the Roman 2. The mode, you see, I've underlined the question itself, because later on you will see that mode of commencement of the intended proceedings, and in which court and where to file the legal action. So from here, there are three things you have to discuss. First thing, we go on one by one. First part is the mode of commencement. What is the appropriate mode of commencement for this action? Correct. Order 5, Rule 2. And then under Order 5, Rule 2, you also have to illustrate a bit. Don't let them think you are just simply throw an order and then without any justification. You have to write out because this is substantial dispute to the facts. Okay? So even one sentence or two sentences will be suffice because as long as you can substantiate your reason for quoting this order. Okay? Then we will go on to the second part, in which court and where to file the action. This will cover two things lah. First thing, in which court? Which court? Okay, we're looking into the facts again. So, sorry, my maths is not that good. So, because a monthly fee of 100,000, so they stop making the payment since February of 2024. And then assumingly last year, they take the exam in this month. So how many months and how much of the money is being claimed? Let me see. February and then April, they demanded. Okay. February, they demanded. Okay. And then now, okay, so we start one by one. February is first month. March, April, May, June, July, and August. So total is 700. Okay? Since February, okay? So February, March, April, May, June, July, and August. Because by a letter dated on August. Okay? So the total number should be 700,000. So if 700,000, which court? Yes, Sessions Court. Okay, any section? Okay, for anyone quoted 61 sub B, I'm so sorry to say that this might be wrong. Because you see, 61B says that up to 1 million is for others' action. Maybe you all can look at the section 65 sub 1 sub A. Unlimited for motor vehicle accident, landlord tenant disputes, distress action, which is unpaid rent. Got it? Can anyone see the section now? Or you all are still flipping through it? Okay, I'll also double check on my side. Sorry, wait a minute. Hey, sorry. I think I got it wrong already. Sorry. Thanks for the clarification. Sorry. I really sorry. I also confused myself in the first place because this is regarding for the distributor fee. Sorry. So everyone who is saying 61 sub 1, 65 sub 1B is correct. Sorry. I'm really sorry for that. Okay. Sorry, I got myself confused already. Okay, so the third part is, okay, so everyone is okay? Okay, so the third part is where to file the legal action. Anyone? Okay, since someone say it's in Malacca, anyone have other thoughts? Okay, got two for Malacca. The third one? Okay, finally I can see some different answer. Okay, so we can look at the section 2 of the third schedule of the Subcourts Act. What does it say? I will say one by one. The cause of action arose. Okay. Second thing, the defendant resides or having a place of business. Third thing is on the facts where the facts on which the proceedings are based exist. So we go back to the question again. So the first thing is Malacca, because Ma and Co is having their business at Malacca. This one suffice. Second thing, Densa is to provide and allow the firm to use one of the building owned by them in Kuala Lumpur, which is the Densa showroom. Okay, so to me, right, the distributory is taking place at this place, okay? So according to section 2 of the third schedule, or if you don't know, if you already know which particular section it is, quote section 99A of your Subcourts Act. Then your answer can say that in either KL or Malacca Sessions Court. Is that okay? Because, okay, so I will guide you all how to start off. First thing, mode of commencement. That will be your first subheading. Okay, because you have to explain how to go on for the mode of commencement. So your mode of commencement already saying that it is Order 5 Rule 2. The reason why? Because it's substantial dispute as to the facts. Then the second subheading, in which court, because now in which court, it doesn't mean that where to file, because in which court, it says that which court has the jurisdiction. So a court to determine which court is appropriate to file the action, according to Section 65, Sub 1B, the monetary jurisdiction is below 1 million. And based on the fact the arrear amount is 700,000, so Sessions Court will be the appropriate court to file the action. Now we come to the third subheading, which is where to file the action. So to determine, okay, you have to use Section 2 of the third schedule and give them the criteria. Where is the cause of action takes place? And then where is the defendants having a place of residence or having a place of business? Third thing is the facts are alleged to exist. So based on the fact, it involves both Malacca and KL. So therefore, can be found in either KL or Malacca. Is that okay? Okay. Yes, Malacca will be appropriate, but we also have to give them some possibility lah. Because since you already say that in your answer, you can say either one. We don't want to assume, we don't want to make a decision on our side, because the decision somehow, when you already written a possibility, you just give them, because because the first thing is we don't even know which type of the examiner we will be dealing with, and we don't know their mode or their approach of marking. Somehow they need a very detailed answer. Some of them might be a bit flexible. This is what we don't know. It's beyond our control. So when we already given the possibility, we just give a general and simple answer by saying that can be found in either Malacca or KL. Yes. Okay. Now you see, part B. Having been served with the legal action pursuant to paragraph A, the firm wants to specifically enforce the distributorship agreement and claim damages against Densa Sdn Bhd for the loss of profit in excess of millions ringgit due to the complaint about the usage. Okay, now you see the question. Prepare a note on the firm's intended course of action against Densa with specific reference to the monetary jurisdiction. This is your first keyword. And then of the court by reference to relevant procedures and the applicable legal principles, so that you see how many underlines I have put it means that how many things you have to discuss. So the first thing, intended course of action against Densa Sdn Bhd. What will be the intended course of action for Densa, against Densa, sorry? Okay. Let me see here. Source of answers here. Okay. Counterclaim. Okay. Correct. It's a counterclaim. Okay, correct. This is a counterclaim action, but it doesn't necessarily for a separate suit, because although you are in the original action, in the counterclaim, that could be bound under the same action. Number of the case will be same, just that they will cite as in the original action, plaintiff and defendant. In the counterclaim, the plaintiff can become the defendant and the defendant will become the plaintiff. Okay? But this one, because you see, the sum of being claimed is more than millions of ringgit. So we will start. We already say that this is counterclaim for their intended cause of action. Now we go to the monetary jurisdiction. Which court has the jurisdiction? High Court, correct. Section? Yes, correct. Section 69A. Now we already dealt with the intended cause of action and the monetary jurisdiction. Now we come to the relevant procedure. The relevant procedure is how to file the action. Transfer. Okay, transfer is okay, but what is the relevant order? Under counterclaim is 66 sessions court. But okay, Francis, to answer your question, right? So since they are claiming for excess of millions, so if you go back to the section 66, which means that they are viewing, let me check for the sections again. You see, the counterclaim by defendant, you see, the section 66 says that the court may still try the action, but when you try the action, right, the court will not be awarding the sum more than million. Okay? Okay, so now you see the problem is here, claiming in excess of millions. So if you are using section 66, at the end of the day, the money they're claiming will be lesser than 1 million, which I don't think so is feasible. We are now, advising the firm. That's why we have to go on order 57. Okay, so in order 57, this is the relevant. Okay. Yes, correct. Because the governing order is order 57. So we start off with order 57, rule 1. Then we can, because now the reason why I use order 57, rule 1 first, because you have to introduce why you have to transfer to the High Court. Then order 57, rule 1 will tell you and will give you an introduction on the reason you transfer to the High Court. Okay? Is that okay for everyone? After we talk about order 57, rule 1, then we only go for order 57, rule 2 on the procedures. Is that okay? Paragraph 12 of the CJA. What it says,
Because the paragraph 12 of the CJA saying that the High Court has the power to transfer horizontal and vertical cases from subordinate court to the High Court, or High Court to High Court, applied by the ways of original summon.
I see. But this one I never encountered before.
Because without the CJA, so if you apply order 57, it doesn't have a jurisdiction.
Okay, since you have said that, let me go to rules of court. You see order 57, rule 1, rule 1 sub 2, a transfer of any proceeding from sub-court to High Court. Hidden power, the inheritance power. The inherent power is to prevent, if I'm not mistaken, the inheritance jurisdiction is to prevent a miscarriage of justice. Like for very special cases, but I don't think so it's applicable in this question now because we are just talking about the transfer of proceeding. That's why if we look at order 57, rule 1, sub 2, you will see. You see, sub 1 says that where the judge of the High Court, judge of the High Court or the judge of a session court satisfied any proceeding can be more conveniently or fairly tried in some other coordinate jurisdiction made on an application to transfer to other court. And then sub 2 further says that the transfer can be from a sub-court to a High Court.
Actually, it's copied from the CJA para 12 and the SCA para 3. They combine together of the power transfer.
That one I'm so sorry. This one I never encountered before. That's why I will only base on rules of court because currently the original action starts from a sub-court. So when you want to transfer, you just follow the order 57. I think should be enough to answer already.
Okay.
Okay, so after we already said, we already explained on the Order 57 Rule 1, then we can go on to Order 57 Rule 2. Then that will be your full answer already. Is everyone okay on this?
Yep.
Okay, so now, okay, this question, for question 2, right? Raja was treated by Dr. Wong and Dr. Ismail. So you see, Raja, one color, Dr. Wong and Dr. Ismail, two different colors. And then Raja claimed the negligence of both doctors, his condition worsened, filed a writ action subsequently to them, and for the negligence. Raja informed Dr. Wong and Dr. Ismail that he would accept 500,000 as damages from them, which is much lower than his original claim. Now, Dr. Ismail is prepared to offer 250,000, being 50% of the offer. But Dr. Wong has refused to offer any settlement to Raja. Now, Dr. Ismail is unhappy with the stand. And because Dr. Wong considered it as unreasonable and would lead to excessive legal costs. And then now we are advising Dr. Ismail on the procedure he should adopt that will require Dr. Wong to pay the cost and also indemnify him for the cost Dr. Ismail is liable to pay Raja in the event the court assess the damages due to Raja is below 500,000 at the trial. So anyone has the thought of the answer? This is exactly, I would say this is exactly same as the past year question. Even the fact also exactly copy, bullet one. Yes, correct. Offer to settle. Order 22B. Because whenever you see, here are the things. Currently, both defendants were being sued. And then now, Raja, the plaintiff, offer a sum to settle everything. So when you see this kind of questions, right, usually this is related to the chapter of offer to settle. So to start off with offer to settle, right, how do you all start off with? Form 43 in Rule 1. Okay, I think we can start off like this. Introduction, you write, because currently you are advising on Dr. Ismail. So you can start off with the introduction, which is, this is related to the offer to settle under Order 22B, okay? So the next step is the procedure. First thing, as what they say, as what everyone said, he has to serve any party, serve on the other party to this one, okay? 137, huh? Okay, I think you go too fast already. So we start off with 22 rule 1 first, 22B rule 1 first. Okay, so because now this question is how many marks? 8 marks, your introduction. Then the first procedure is you have to talk when is the time to the timing, so which is order 22B, and then the time for the acceptance, rule 3. Then we only go to order 22B, rule 11, because 11 looks like this is towards the end already. So in order to secure 8 marks, you have to go on with the introduction, and then the relevant things will be involved. Then you only go to the end, because if you start off when you talk about rule 11, it is towards the end of the question already. Okay. Okay, I will rule 10. Right. Joint and several liability. Yes, this one you also have to cover a bit. Correct. Thanks for highlighting. Anyone has question? Not related, but not related, but you can help to explain more on 9-2B. You see, the 9-2B, it says where an accepted offer to settle does not provide for cost, each party shall bear their own cost. Offer to settle made by a defendant is not withdrawn, it's not accepted and is not accepted by any of the plaintiff, and the plaintiff obtained judgment not favorable. But this one, as you can see, now it's still starting stage, and then none of them are going to accept anything. Only one person, which is Dr. Wong. And then this question, I just found a question, is exactly same as the year 2020 supplement question. Name also macam same. Yeah, Dr. Wong is the common party lah, okay? Because this is exactly same as the 2020 supplement paper. And then this is how am I starting off. First thing, you intro, just a general introduction saying that this is related to offer to settle. Then on how they should, on how the acceptance and withdrawal, you just briefly discuss that in one sentence, and the timing, because at which point of time they can either accept or I'm sorry, it's when an offer to settle can be made, at which point of time. So this is governed under Rule 2. But now when it comes to one party is not accepting, you have to go on to 22B Rule 10, then goes to 22B Rule 11. Is everyone okay? Contribution and indemnity CLA, Civil Law Act. I think when you're saying rules of court, it should be more than enough already because there are a lot of things, plenty of things for you to write already. Okay. Okay, we come to here. It's part B. Supreme is a well-known MNC incorporated in UK. Filed a writ action in January 2024 against PQR in the KL High Court for a claim of dishonor of check. And then Supreme Limited has supplied electronic equipment to PQR, issued post-dated checks to Supreme in purported payment, were dishonored upon presentation for the reason of insufficient fund. Pleadings were closed in March 2024, and the trial is fixed in December 2024. Few days ago, PQR filed an application in court supported by affidavit for an order for security for cost of 100,000 against Supreme Limited on the grounds that it is a foreign plaintiff and will likely unable to pay the cost if ordered to do so. Now, you are advising Supreme Limited whether it will be ordered to provide security for cost. Okay, so from this question, anyone have clue? Yes, security for costs. Order 23, Rule 1. Okay, since we are advising Supreme Limited, when you talk about this kind of night, actually, when it comes to about 10 marks question, right, better have an introduction. Because if you didn't introduce the fact and straight away tell the procedure, your 9 marks or 10 marks may not be able to secure lah. So for me, right, when I see this type of question, I will start off with introduction. Because the introduction itself, you have to briefly explains the fact why you are going to use Order 23, Rules of Court, Security for Cost as your first answer. Then you only talk about the relevant procedure. So when you start off with Order 23, Rule 1, saying that the principle, what are the principles for security for cost? Like the plaintiff is ordinarily residing out of the jurisdiction, or P is a nominal plaintiff suing for the benefit. Okay, then the third one, the address is not stated in the writ. Fourth one, he changed his address during the course of proceeding. Then you explain on whether they have sufficed or satisfied each of the requirements. So now we're looking at here, Supreme incorporated in the UK. So currently, this is very likely that he has hit one of the requirements, which is ordinarily out of the jurisdiction. So, okay, you already justified first requirement already. Then now you have to go on to the second part, which is the principles considered by the court. Okay? So in principles considered by the court, which case were you referring? Correct, Sir Lindsay Parkinson. And you also have to itemize the factors considered by the court, like bona fide application, whether there is any oppressive conduct, and then success by the plaintiff is reasonable. Just either three of them will be enough. Now, we come to the conclusion. The conclusion is whether the security for cause will be ordered by the court. This will be a fourth part already, because the first part is the intro. Second part is the procedure, okay? And then you justify why they can use. Third one is the factors considered by the court. Fourth one is your conclusion already. Conclusion is whether the court will order. Now, after considering everything, you are advising Supreme Limited. Of course, you have to cite two cases. Anyone? Okay, first case I will use is this case. So the reason why I use this case is because in this case, the court held that although the plaintiff is a foreigner, doesn't mean that the security for cause will be given. Okay. Second case. This case, the PQR has incurred dishonor check, no defense. That's why I'm using this case. Adarsh Pandit. In this case, the court held that although you're having a little sum of money, okay, doesn't mean that you can simply order for the security for cause, because at the end of the day, the court is still looking at the fact whether there is a necessity. But okay, since you already say that, causal lag, let me see the fact. Consider the fact. Okay. Absolutely very weak also. Okay. Okay. Okay, I think, okay, I can see most of the cases here. The fact, the reason, okay, let me a bit explain now the reason why I use those cases because I'm looking at to advise Supreme Limited. So having said that, we are advising a foreign company. We have this is my personal comment now. I also make sure this will not granted. That's why I'm using those cases. But you can, I didn't say that the cases given by you all are not correct. Just that it's less favorable to your client. That's why at the time, if we are currently advising PQR, of course, those cases you all given in the group chat. Yes, that is correct and absolutely on point. But however, looking into the fact, I have highlighted this part. We are advising a foreign company. So what does a foreign company want? Of course, the security for cost will not be granted on them. Okay? But you all may use those cases. Just that I also worry that maybe you all might go off with the question now. Because looking into the facts, right? So let's go on one by one. First thing is, Pozilek, the court held that the court has the discretionary power to order security for costs. Okay? But they will consider first the success of the plaintiff in the action, the solvency of plaintiff, and whether the order will be unjust and inequitable, unnecessary prevent plaintiff from continuing with the case. So this is left favorable to the Supreme. Second thing, Farida Begum, the court may order security for costs if the plaintiff owns property in a country with reciprocal enforcement of judgment agreement with Malaysia. This one is just filing only. It's not a reciprocal enforcement of judgment. Reciprocal enforcement of judgment is governed under REJA, Reciprocal Enforcement of Judgment Act. That one is very, very go beyond because they did not enforce the foreign judgment in Malaysia. So that this one is unlikely related. Okay? Can we go on to the third part? Okay, the third part is ABC obtained final judgment against Chan. Chan refused to settle the judgment sum. Inform ABC he does not have the means to settle the judgment sum. And now ABC has reason to believe that Chan is able to settle the judgment sum and may have some assets, wants to summon Chan to court for an oral examination to ascertain his assets for an order that he settles the judgment sum. Advise ABC on the procedure to compel Chan to appear in court and the consequence that may ensue if Chan fails to settle the judgment sum after being ordered to do so. Anyone have thoughts? Order 48 and Section 4 of Debtors Act. Section 4 is prefer over 48 because only allow ABC to examine of judgment debtor and cannot be an order to settle judgment sum. Okay, let me read through the Section 4 first. When the judgment of a court is for recovery, whether by installment or reverse, A. Sorry, any person can make order to payment. Okay. Okay, I've seen two answers here. First thing is your Section 4. The Section 4, it governs of the Section 4 of the Debtors Act is a governing section of your judgment debtor summon, so that this is essentially provides in Order 48 of your rules of court. Okay. Now, the procedure to compel Chan to appear in the court. So I think 48 should be enough already. But Order 74 Rule 11 is only on the Debtors Act. Thanks for your highlighting, Francis, because I'm flipping through the Order 74 at the time when you are telling me, when you're highlighting on this order, right? I'm flipping through the Order 74 because Order 74 is for the following the Order 48 and the Debtors Act. So at the end of the day, we also have to go back to Order 48.
Because 48 cannot make an order for payment, but you only can check the book only. If they have money inside there, you cannot order them. But under the Section 4 Debtor Act, you can allow the court can make an order for the payment.
Okay, if that is the case, right? I'm also flipping the Order 48 as well. Just now you say which order? Order 48, which rule?
Because order 48 only examinations of your judgment debtors, whether, like example, the order 48 rule 1 is saying that you examine the books only. But it doesn't give you the order. It's saying that because the part here is you need to ascertain whether you can compare the ABC to whether they have whether to summon Mr. Chan to have money to settle the judgment sum or not. But under section 48, you only examine the books only for Mr. Chan. But you cannot make order. But under section 4, you can make order. Order 48 doesn't give the court power to make order for payment.
He wants to compel Chan to appear in court only or no?
There is two ways. One, we want to compel him to make payment, or we just want to check the book only. Two answers.
I see. Maybe I think you're going too details already. You see the question itself, the facts is very lengthy. I can understand the way that you are being caught by a question. Now, the first thing is you want to make sure he can appear into the court first. Okay? Then you only examine whether he has the money to settle all the things.
Yeah, right.
Yeah, this is a two-way things. First thing, we must make sure the person attended before appear in the court. Otherwise, the further step cannot jalan one. If you don't appear in the court in the first place, how are we going to ensure that they can make the payment? Or do they have the means to settle? So now the question is saying that to compel Mr. Chan to appear in court and the consequences. So now the first thing is we must make sure that he can be compelled. So under order 48 and the section 4. Then we only go on with the next procedure. Order 48, rule 1 sub 2, which you already mentioned that anything to support. Okay?
Okay, good.
Okay. So after the order 48, rule 1 now, let me see. I think for this order 48, right, since we already there is only 3 rules. So 41, rule 1 sub 2, we already talked about it. Then order 48, rule 3, we also have to say that the registrar has to record the debtor statement. Okay? Okay, then when it comes to a conclusion, you have to add something lah. If the failure to comply by the Mr. Chan, upon everything is being recorded, then he is liable for a committal proceeding. So does everyone know what is a committal proceeding about? Okay. Contempt of a court order. Yes. Committal proceeding is a very special thing in the civil court, because normally in civil court we only talks about money and cents. But this is the thing. When it comes to a committal proceeding, somehow, if you fail to follow the court order, you may be in prison. Like what leads to a committal proceeding? First thing is you didn't follow the court order lah. Because currently we are saying that in order 48, rule 3, when the registrar has recorded everything, which means that there's a final order against you, you have to comply. If you don't comply, okay, you have to serve the sentence as given by the court lah. This is a very special arrangement in the civil court. Okay? Okay, now we come to the third question. Paul rented a shop house in Shah Alam to WXY. Monthly rental is 5,000. And now WXY, since August 2024, defaulted on the payment of the monthly rental. Now Paul has filed a writ action against WXY for vacant possession and arrears of rental, served the writ on the company. WXY has failed to enter an appearance, although period has been lapsed. Okay, now we are going to advise Paul procedure to enter default judgment against WXY. How do you all go about it? Okay, since this one is the procedure to enter a default judgment. Okay, I saw one answer here. Advised. Okay, for those who answer Order 13 Rule 1 straight away, is good because you answer half of it only. Yes, correct. Order 12 Rule 4. WXY has to and is given 14 days to enter an appearance. Okay, so on the fact that he did not enter into the appearance within the 14 days, then you only go for Order 13 Rule 1. That will be your full answer. Okay? Now we come to Romans 2. Romans 2, the procedure to evict WXY from the shop house in the event that the company remains on the premise after judgment is entered. What do you all think? So the answer is Order 13 Rule 4. Because you want the possession of immovable property. So the answer to answer Romans 2 is Order 13 Rule 4. Is everyone okay? Okay, now we come to the part B. A deceased man's widow filed a writ action against executors. And then now the executors have verbally request further details because alleging that the deceased was suffering from a disorder at the time the will was executed. Then now the will is invalid. So now the executor verbally requested further details of the alleged disorder of mind but the information has not been forthcoming. Advise the executor on the procedural steps that they should take to avoid being taken by surprise at the trial due to lack of details. Okay. So what do you all think for this question? To Diana, this was my initial answer, but subsequently when I read again, this is not. Yes, this is discovery. The reason why I got being caught by a question initially is because they want the further details. But when I read through the facts, right, now they are suing each other in the court. And now, because lack of the details, they want to know it. What happens to the alleged disorder of mind? So they need certain documents. So this is related to discovery under Order 24. And then now you have to bear in mind, this is during the action already. It's not against other, you want the documents or anything, but not other person. So it is falling under Order 24, Rule 7. Is that okay?
Order 26.
Order 26?
Yeah, because it's called discovery of facts, man. It's not 24 discovery of documents.
Let me see. Order 26.
Because it's verbally request for further detail, it doesn't mention that it's about the document because Order 24 is inspection of the documents. But Order 26 is talking about discovery of facts, which is in questions and answer.
First time I encounter this as well. But when I look and read a question again now we are talking about the disorder of mind. Okay? And this is what they are lacking of. They want the information. But interrogatories usually is disclosed of the facts one.
Yeah, correct. Because you need to have a lot of facts to justify. Because what type of sickness? Because you have various type of disorder of mind. How long have it been? You know, because if you base on documentation, you cannot justify.
Based on the document, they cannot justify.
Yeah, because you have a lot of questions being asked. So this sort of discovery of facts is still based on question and answer. They need to provide the history.
Correct.
Yeah. The defense lawyer can ask a lot of questions in the discovery of facts. Instead of the document, you have limited discovery because you just based on whatever you've been provided. But in discovery of facts, you have a lot of things to ask them. So you get more things, more answer from the other side.
Okay, I can see where are you coming from. Because the reason why I'm using 24 instead. The problem is when we are using 24, the information must be given by the parties in the action first. So now they already requested the information, but now they didn't provide it. And this is like what I said lah. Now you didn't provide me, and then suddenly the information's at the first stage you didn't provide me. But suddenly when you come to court, you throw everything. It's like throwing me a surprise lah. So if you look at the discovery under Order 24, right, one of the function is to eliminate surprise. That is the reason why I use Order 24 in the first place.
Yeah, because it doesn't want to cooperate in the first place. So even though you come to discovery of document, later on you can have a lot of denial. So if you discovery of facts, you have no way to run because the product in the form itself.
Okay, before
So you much more confined because it's now.
Go on.
If you put in the discovery of facts, that means you can ask more questions. So he cannot run from the facts later on.
So you are using Order 26 lah.
Yes. Because you need to because you need to corner him.
Oh, I see.
Because in the first place he don't want to cooperate. If in the first place he want to cooperate, he give us the document easy.
Oh, I see. So is this based on your working experience or what? Because sounds like you are quite experienced.
Yeah, that's a discussion.
I see.
Much more in depth, you know.
Oh, because the way how you talk to me is like, I'm just like the feeling in my gut feeling you are like working quite a lot of experience because my answer is more on academic, so it's more on theoretical. So when it comes to practice and practical, this will be a separate round. So I'm welcome for the new thoughts. That's why when you come across with Order 26, right? Yes, they have to disclose the facts, but now the problem is they don't give me the information.
Yes, so they want to give information, so we move another step. You don't want to give me information, I ask for discovery of facts. So you need to answer that. You cannot run.
Yes, this could be okay. Since you already say that if you don't give me the information, then I only come to the next step. Are we on the same line?
Yep.
So now the first part is we want to make sure they give us the information.
Correct.
That's why I start off with 24.
But the patient says that he verbally requested further detail, but he denied. He don't want.
That's why now they go to court to apply lah.
Yep.
Yeah, that's why now we come to court to apply is under Order 24 first lah.
We want to collect marks.
Yeah, but the problem is sometimes This is what we usually think of. We are thinking that we know quite a lot of things, and then we go too much further already. Sometimes this will be how will I say, this will jeopardize us, because when we go too further, we go off from the question. Now, the first thing is to avoid being taken by surprise. This falls under one of the function of discovery. So for question 3A, can I write? Okay, for seeing this question, I will answer you later. So for this one, if because to Francis, right? I know you study quite well, because most of the orders you provided in the chat group, I have to also flip again my rules of chords, But from this question, right? Because on the surface itself, as being underlined, to avoid being taken by surprise due to lack of details. Now, that's why I'm using order 24 instead. Is everyone okay? Okay, so let me go through order. Okay, so let me go to Cindy's answer, to evade. Okay, so your order 45, let me flip again.
Yeah, I also have the same thought on this. Just I forget about it. Order
Rate of
45. Because that's why you're using order 13. So I also think of like Cindy, order 45.
Rate of possession. Okay. So since you all have a concern on the rate of possession, let me think about it. The 45 macam is the full judgment one. Because as you can see,
45 can be judgment in default for possession of the immovable property. But order 13 rule 4 is
45 right, is to command the sheriff. Now is Paul wants to take one.
correct, because order 13 rule 4 is talking about the dependents fail to enter an appearance. Then after that, the plaintiff, claim for the possession of immovable property.
Okay. But now just saying that
Also order 13 rule 4 also talk about the enter judgment for possession under order 83 rule 1.
Yeah, the problem is right now we are advising Paul, and Paul wants to know how to evade. Okay, the procedure to evade. So we use order 13 rule 4 should be enough already, but very
Because you want to evade him, you need to go for enforcement of judgment.
okay. Let me read it once again now. Because at the end of the day, when I look into it, this is not a final judgment, it's just a judgment in default. Okay, so to answer your question, right? Does judgment in default consider as a final judgment?
No.
Of course, he has 30 days.
Correct.
So order 45 is more applicable when it becomes crystallized. And now they are still in the midst of the JID stage. So order 45 is unlikely applicable here lah. Because it's now still in JID stage. Yes, after
Right.
30 days of judgment. That's why I'm not sure if everyone has taken bankruptcy. Because the bankruptcy, the first thing you must know is JID is not a final judgment. Because when you want to ensure that the judgment debtor has committed an act of bankruptcy, the first thing is you must obtain a full and final judgment. So even though when there is a judgment in default, that has the 30 days time frame to set aside. So
Yeah.
now we are dealing with a judgment in default. That's why we cannot go too further like order 45. This is given in the case of what case again? The Udos case. Okay.
Okay, good.
Re-Udos. Yes, Re-Udos, if I'm not mistaken. Okay, so oh man, now it's 2:48 already. So I will settle off this question, then we call it a day. So now, question C, a plaintiff filed OS against a defendant. Upon being served, the defendant made an objection on the grounds that Malaysia is not a proper forum for the dispute. And the defendant has also made a further objection that there is a serious dispute of facts with respect to the cause of action. Now, we are advising the defendant on the procedure the defendant should adopt in respect of the two objections that the defendant has raised. Okay, to me, right, this question is quite fresh to me, but does anyone know how to go about? I saw the answer already. Conversion of action. Conversion of action. The reason why I say this one is quite fresh to me because this is the first time I saw them asking in such a way. Because initially when you're dealing with this kind of question, right, when they say Malaysia is not a proper forum, this usually refers to the arbitration clause. And then the case is Elf Petroleum, where the court held that the Malaysia court has the appropriate jurisdiction. But later on, when I read it again, there's a serious dispute of facts. Okay? So now, this is dealing with the conversion of action, Ding Ling Q's case. Is everyone okay?
If may I have a case name?
Tingling Q, TINGLINGKEW. Let me type Yes, it's order 28 rule 8. But now you also have to use something. Yeah lah, the Malaysia is not proper forum, it's just red herring lah, because the end there serious dispute ma. Even I also got caught already. Because the first thing is, you see, I think I'm not sure who is the one who asked me already, order 2 rule 1. This will be part of your answer already. First thing is the plaintiff initially has used OS instead of the read. Okay, now they made an objection already and saying that this is a serious dispute of facts, which is caught under order 5 rule 2. So that in your answer, you also have to discuss on the order 2 rule 1. The reason why? Because wrong word use is only an irregularity which can be cured. Okay? So this will go back to your overriding interest. And then once you already say that, to substantiate your answer, so the first so the intro is wrong mode use under order 2 rule 1, because you have to know you have to say that he should use read action instead, but he has used OS action. Now the second thing is why you say order 5 rule 2 the read action, because there's a serious dispute of facts as alleged by the defendant. Okay, so that moving onwards, then we'll go on to the conversion of action and the case tingling Q. Is that okay?
Yep.
Okay, so these 3 answers so this will be the questions that I am going through with you all for today. Okay, I will stop sharing the screen and stop recording and now.